So welcome everyone for the Free Russia House event. Tonight we are talking about the Magnitsky International Accountability Law and first results of its activities and of activities of human rights defenders who is now using it in a way to stop human rights abuses around the world. We are welcoming today in Kiev Melissoi Huper, who works for the Human Rights First, and human rights organization which is an international leader on actual implementation of the Magnitsky list and on searching for those human rights abusers who are suitable to put it under Magnitsky list. I'm also honored to say that Melissa is now a part of the board of the Free Russia Foundation. Thank you for this. Thank you for joining us.
Yes.
Thanks for coming tonight, and I'm just going to start with a question in a more general way. Magnitsky International Accountability Act was implemented in 2016. Since then, a number of people, not only from Russia but from different countries, have been put into the list with your help, with help of your colleagues. And I just wanted to hear your assessment of how the law is being implemented now and how effective it is. And who are those first people who went to the list?
Made it. Okay. Yeah, thanks for having me. It's great that I get to come to Kiev. I haven't been here in a number of years. So I'm happy to be here and happy to talk with everybody. And I'm curious to hear your thoughts on where you think Magnitsky could be more helpful and useful. So the Global Magnitsky Law, as probably a lot of you know, grew out of the Russia Magnitsky Law, which was passed in 2012. And the difference is that, well, there are many actually differences. The Russia Magnitsky Law, you may recall, states that the US government will sanction, so it must sanction those that commit gross violations of human rights in Russia that it finds meet certain criteria. The Global Magnitsky Law is not mandatory, it's elective, so the US government can sanction these individuals. The Global Magnitsky Law also, though, is broader in that it encompasses corruption. So the law itself actually said that if an individual commits gross violations of human rights or substantial acts of corruption or acts of substantial corruption, then they could be put on the list. Again, elective. However, there was an executive order signed by President Trump after that modified the standards and made them a bit easier. So the Global Magnitsky Act, unlike the Russian Magnitsky Law, is global. It really is, you know, I've heard some people say, oh, it only applies to certain countries. No, really, anywhere in the world. And we've even toyed with whether people in the US might be put on the list. And it actually is true that if someone has dual citizenship, they could be put on the list. Anyone can be placed on the list if they commit an act that fits the standard. So I said that the standard was changed or modified a little bit after the act was passed in December 2016. In 2017, Trump signed an executive order that stated that when he signed the list of sanctions for 2017, there were 15 people on this list in December. He said that the new standard will be, or he didn't actually say that the new standard will be, but that those will be put on the list if they commit serious human rights abuses or acts of corruption. Pretty broad. So acts of corruption is now, you know, even the minimal standard. So what has happened since 2016, December? We have had, you know, 2 years of using the act. First, we have seen that NGOs have been very involved in preparing cases and suggesting designations. Shortly after the law passed in 2016, Human Rights First decided to gather a group of NGOs, and we actually work closely with Freedom House on this. And And we right now have about 75 or 80 NGOs that are not just from the US, but they're from all over the world. And we meet a couple of times a year, and we identify regions and countries where we think it's important to prioritize cases. Then we identify individuals, and NGOs with expertise in those regions and on those countries prepare the cases. So, it is those NGOs that have the expertise that are doing the preparation of the factual basis of a case, which is all in written form. We have seen this develop because the US government has been very committed to including NGOs in the process. The Global Magnitsky law specifically mentions that Congress and the State Department will consider the information, credible information from NGOs that present it to the government entities. So the Act contemplates this, and we have met with the State Department a number of times, and they have said that they are very interested and very, in a way, reliant on us to give them good information. So they are looking to us to identify where are the real needs. And I think that our involvement also helps prevent, not completely, but it helps cut down on political use of the Magnitsky law. So we've seen a lot of NGO involvement. We had a smaller coalition the first year. We grew the coalition the second year. We learned some lessons the first year that we implemented the second year with the coalition. We've seen a lot of acceptance from the US government. When we did our advocacy meeting with the State Department and the Treasury Department in this summer, so our second round advocacy meeting, we actually met with 3 top-level State Department Deputy Assistant Secretaries who listened to all 15 of our cases and said that they were very impressed with the level of detail, and they were taking all of them under advisement. We've seen a total of, so in those 2 years, we've seen a total of 101 designations. They're in 18 different countries. That just changed recently with the addition of Saudi Arabia in November, and then Burma was a couple of months before that. I would say 101 total designations of individuals. 2 of them have been removed from the list, and that's, I referenced political use of the Magnitsky Act. I would say that we have had one instance where we really think that it was misused by the US, and that was in Turkey, where the president sanctioned 2 individuals that were involved and responsible for the arbitrary detention of a US pastor, Pastor Brunson, in Turkey. And with all that was going on in Turkey, with torture and even disappearances and mass arrests, and violence against many sectors of the population, for the US to use Magnitsky against 2 people who were involved in arrest of 1 pastor, we thought was perhaps not the best use of the act, and so we wrote about that. In terms of how it worked, well, the pastor was released, and so that those 2 individuals have now been taken off the list. So that is also evidence that people can be removed from the list, which is something that isn't directly provided for in the law. So we were wondering how that was going to work, and that helped us. When you ask how is it working, I think that the process is therefore working because NGOs are very involved. The State Department has said that this is one of their main human rights priorities. So on the issue of Global Magnitsky, it's an issue where we can actually work with the Trump government, which is, there aren't always places where we can do that. And that's positive. If you're looking for the answer to whether sanctions work, that's a long-term question. And I think other than the Pastor Brunson case, which again is not my recommended favorite case, it is difficult to determine whether the sanctions against individuals in Burma or Saudi Arabia or the Congo are having an effect. I do believe that it's painful to have your assets frozen. So the two things that happen if you get put on the list are that all of your assets that are within the US are frozen. They're not taken, but they are frozen so you cannot access or use them. And then you are subject to a visa ban. So you cannot enter the US. And for those that have some money or property in the US, I think that it is painful. Or that might want to come take either a vacation or send their children maybe, although their children won't be banned under this, under Global Magnitsky, they wouldn't be able to visit their children, you know, or, I don't know, come for some other reason to the US. It can be, it at least makes people feel some level of pain. And I think that that's something that the Treasury Department considers when they determine who to put on the list.
All right. Melissa, can we now focus on the cases which are more relevant to the Eastern European agenda? Cases from Russia, Ukraine, or let's say Caucasus. Who are those people who are now on the list and who are from our region?
So that's a good question. I don't have all of the 101. So, you know, some of the well-known cases are Gulnara Karimova from Uzbekistan. I think many people cheered when she was put on the list. She was on the list in 2017. Артем Chayka, who is the son of the Prosecutor General in Russia, is on the list. Those might be the only two that I know for sure from this region who are on the list. There are a number of people who have been put on the Russian Magnitsky list, you know, or at the same time.
Yes.
Or yeah, like sort of, you know, they've been tracking and issuing sanctions. Like Kadyrov was put on the Russia Magnitsky list, like in the last 2 years, like issued in a press release at the same time, but it was not Global Magnitsky.
Okay.
So it's, you know, it's expanding use because I think they're trying to focus on corruption cases from this region.
Okay, talking about Karimova and Артем Чайка, who initiated this? Was it your initiative or the cutoff or other NGOs to put this person to the list, or it was a State Department initiative?
So in terms of how many of our cases from the NGO coalition have ended up on the list, there actually are, I would say, fewer than 10 of the 101 we have specifically recommended. And that is because I think that the State Department has been responding to what is going on in the world and recent developments in sanctioning a number of groups. So, you know, like recently the Saudi Arabians, there were 17 of them, and then the Burmese, there, you know, were 8 or 9 Burmese, and so they have these chunks that they do in response to treatment of the Rohingya or the killing of Jamal Khashoggi. And so, as we go back, you see then, you know, Nicaragua, you'll see a chunk, and you'll see sort of groups of individuals that are put on the list. And so, I think that what's happening is that the State Department is taking all of our, this is what they've told us, they're taking all of our information, and then as they have every year sort of they try to do an emblematic set of human rights cases. And they use our information mostly for those, and they have told us that if we don't get a sanction right away, we shouldn't give up, because they are mostly sort of holding them in order to release them in a series. We are seeing them accept some of our cases, and we are told that some of our cases are, you know, coming soon. In terms of those two, Gulnara Karimova, I don't believe that we may have recommended her, like her name, but we actually did not put a case together. I think that we said there's a lot of information out there, and we can pull it together if you want. But there was a lot of information out there about Karimova's, history in telecom dealings. In fact, I think Andrew who's here might have worked on some of that information. And then for Артем Чайка, we pulled together a very, I would say very basic submission at Human Rights First that was just using public information, both in Russian and in English, but just pulling together everything that we could. And I personally think that the State Department had their own information, and that we were, again, kind of offering them a name that they knew and that they had been researching, because we are not the only source. The State Department does their own homework. They don't rely on us completely. They rely on us to target where they should look, and then they do a lot of research. And so my sense is that they had some information on Chayka, they had a lot of information on Karimova, and so we helped them, but I think that in that first batch, that they maybe had some people in mind, and that we kind of helped identify some of those people.
All right, so you're basically saying that those were names which they wanted anyway, and you basically just gave them something they wanted, and the State Department or the Treasury said, oh, all right, we know this lovely people, why not to put them in a list?
Yeah,
but,
they're shining examples.
Yeah, but how your cases work, like on a more general way? What does it mean to pull the case together for the Magnitsky list, if the person is not the daughter of the authoritarian leader? And how much political is the decision on this, and how much it's legal?
Right. So the first part of your question is kind of the technical, how does it work? Mm-hmm. So I'll address that first. Within the coalition, we try to meet and discuss areas and regions and countries where we think it's really important to have a case or have a series of designations. But honestly, we meet as a coalition, and NGOs have a lot of work to do, and this is not always their top priority. Sometimes they're actually in a region, trying to help the people whose rights are being violated, and they don't have as much time to document and then use that documentation in a new framework. So what we found is that it is still difficult to get NGOs to say that they're going to complete a case on a certain country and actually complete the case. It's not any fault of any NGOs, but people are trying to do a lot of things at once. So we've been appealing to funders to try to support NGOs that want to take the information that they're obtaining and use it for global Magnitsky cases, because we recognize it takes an extra step. But generally, we work within the coalition. Coalition identifies cases and countries where it would like to present a possible designee, and then NGOs say that they would like to complete a case, and they identify those that are most worthy of being on the list. And so then they put together all of the evidence in support of the case. Again, it's a written packet, so they describe the human rights violations or the corruption. They describe how this person is connected to the human rights violations or corruption. And then an important part of the global Magnitsky process is describing the US interest in sanctioning this individual. Because there is political wrangling, the US government has to think about why it would be important and in the US interest. The US State Department contacts the embassy in that country and is asking, are we going to blow up our relationship if we sanction this individual? What will happen? And so then they have to navigate that relationship to see whether whether it's the general prosecutor or the deputy general prosecutor or someone down the line that would be most helpful to designate. They're kind of trying to calibrate that relationship. And so we have to offer them some options. And then we have to support everything with a, we try to have two sources of evidence for everything. Because while the standard has been eased due to the executive order, we still have been told that the State Department wants a very tight evidentiary case. Sanctions can be challenged once they're implemented, and so the US does not want that don't meet the standard. So they want us to help them gather evidence that is well supported and well developed. Political use. So there is a discussion of US interests in sanctioning, but I don't believe that that necessarily leads to political use. I do believe that having NGOs involved at the level we are, and as extensively as we are, helps. And I also believe that what's happening now is, we have the presidential administration that has certain interests, but then the people that we're working with day to day who are dealing with global Magnitsky cases, reviewing them and putting them together within the State Department and Treasury are those that have been there through various administrations, and so they are they're watching out for political use, and I think they're trying to serve as a check as best they can. And then we have another check, which is Congress. That hasn't, Congress hasn't always stepped up on these cases, but every year when we as an NGO community come together and we put together 15 or so cases, we have a congressional support letter. So we have at least a Democrat, one Republican who have signed on and said, we also support all of these cases, which is great. And last year it was Senators Cardin and McCain. Unfortunately, McCain passed away, so this year it will likely be Menendez and Rubio. And so, another way of trying to limit political use is that Congress themselves have been pushing for cases. And there are some human rights champions in Congress, I would say like Senator Ben Cardin, who keep an eye on the human rights situation in certain parts of the world. And they will periodically write a letter and suggest certain names for Magnitsky. They also, recently the entire Senate Foreign Relations Committee, except for one person, wrote a letter to the Trump administration and said, due to the killing of Jamal Khashoggi, we think that you need to sanction high-level Saudi officials, and they made some suggestions for who. And this put the Trump administration in a weird spot because, not only does the U.S. have a close relationship with Saudi Arabia, but the president's son-in-law has a close personal relationship with Mohammed bin Salman, so that put him in a spot. They did not end up sanctioning Mohammed bin Salman, but they did sanction a number of high officials, including the legal advisor to the president and the deputy legal advisor and the consul general. So I think that there could have been perhaps some other individuals included, but there was at least a message sent because Congress put pressure on the presidential administration. So I think that there are various levers at work. Congress is one, NGOs are another. Those within the State Department that have a long human rights history, I think, are trying to provide a check. It obviously doesn't always work because we had Turkey. But I think other than Turkey, we have seen a pretty good stream of, I think, bona fide, serious human rights violators and corrupt actors who have been put on the list. I think it's a matter of, at this point, choosing who is more important than who, and for the timing. And I've seen also actually that I said that a few of our suggestions have been accepted. In some instances, our suggestion wasn't accepted, but the U.S. government has chosen someone very similar, and so they're trying to negotiate with us, and we suggested person X, and something won't work with person X, so they choose person Y, but they seem to be having a conversation with us. They're hearing what we're trying to do. That happened in China in particular, and so they're trying to work with us on that.
Okay. talking about the standards and motivations. We are in Ukraine right now, and I could not ask the question about Dmitry, which, as I know, it was an attempt to put him in the list as well, and it never worked. What happened and what was the deal with this?
Sure. So that was also as we were first getting started on both developing the coalition and developing individual cases. Firtash was another person that we thought was a shining example of someone who was widely known to be corrupt. And so we pulled together public sources of information and submitted them to the State Department. We also, this is a lesson learned. In our first round, so 2017, as a coalition, we gathered 15 names, like we did this year, and we decided we'll put out a letter, we'll publicize a letter. These are the 15 people that we want to put on the Magnitsky list. And so we put that out publicly. We learned we shouldn't do that for two reasons. Number one, the State Department, actually the Treasury Department doesn't like that because it tells all of those people that have assets within the United States, look, you're about to get your assets frozen, so you might want to move them. So they told us, don't do that anymore. They actually were, yeah, they were bothered. And so we learned to not do that. We actually now use confidential communication channels with the NGOs to get information from them, and then to also send our information to the State Department. So we don't publicize any of the names of the individuals. We publicize sometimes the names of the countries. This year, we're making suggestions about people in these 15 countries, and so we have done that. The second reason why you don't want to put out a letter saying we're suggesting these people for sanctions is that they will threaten to sue you. And so Firtash did that. He contacted us through a lawyer and said that we were alleging that he was an oligarch and that he was corrupt, and that he would sue us for defamation. And so this just required us wrangling with lawyers for a number of months to negotiate with him. And that made it harder for us to focus on our work, unfortunately. And we also happen to be part of a community of several NGOs in Washington that have been threatened by similar oligarchs who have said that information has been published about them that they disagree with, that they think is false, and they've threatened to sue, and this seems to be kind of an ongoing problem. So as a result, we issued a statement saying that we had no opinion whether Dmitry Firtash should be on the Magnitsky list, and the State Department did not sanction him. So he has not been sanctioned. Honestly, I know that the U.S. was seeking his extradition from Austria on some charges at the time, and so I think that that case maybe played a role, that there was kind of an intersection of those two cases, of those two decisions. And also, I really do think that the Treasury Department probably said, well, now, he's probably moved anything that we were going to freeze anyway, or maybe they even checked, I don't know. And so, at this point, he is not sanctioned.
Okay.
Yeah. He's not sanctioned, and we don't talk anymore about specific cases.
No more Firtash.
Yeah, exactly.
Okay, got it. Actually, I want to move to the questions about implementation of Magnitsky-like legislation around the world. But before that, I would maybe, let's see, maybe someone want to ask a question on the previously discussed things. So then we can just move to another block.
Okay.
Is there any questions? Oh.
Yeah, Melissa, I was wondering if you can talk a little bit about what you have to do to be removed from the list. Like, is there a procedure set up in the Act that allows for that?
Yeah. So this is a major concern as I would say, states are trying to take Global Magnitsky and use it, they keep asking, well, how do people get off the list? Because there isn't actually a description in the Global Magnitsky law of how you get off the list. But how you get off the list generally is, as we saw with the Pastor Brunson case, so it's good for something, you stop committing the violations that are that you were designated for, and then apparently people can be removed by sort of like a petition or an act of the state and treasury saying, okay, we're now unfreezing your assets and we're taking you off the visa ban list. And that's what they did in these cases. They issued a statement. Or you can sue. And that's, that is the sort of more broadly known way of getting off of any sanctions list, is in the United States you go to court, and you go to court only after your assets have been, you found out that you're on the list. So your assets have been frozen, or you are on a visa ban list, and you can sue to then get your name off that list. We have been doing some research on cases where individuals have sued. So far we have not seen cases under the Global Magnitsky Act. We've tracked some cases under other sanctions regimes, and we have seen that in some cases where people have sued, they have been able to get their names off the list. But so far we haven't seen that with human rights sanctions.
Okay. More questions at this moment?
Is the presence of any American ties or the extent of American ties a criteria? For example, if there are two candidates and one has larger American ties with the United States of America, will there be a priority to make the impact larger of sorts?
Right. So, of course, I'm not actually doing the sanctioning. That's the US government. So I have to guess a little bit. But we've had a number of conversations with them where we ask them all kinds of questions about what are they looking for, what's most helpful. Sometimes we get answers and sometimes we don't, and they just don't tell us. On that, I would say that on the question of whether someone has more ties to the US, more property in the US, is that more attractive? I think that ultimately it really is about whether they are seen as a good example of a human rights violator. But if someone had no property in the US, then it doesn't send as much of a signal. And so there is, I think, some, the third section of the form is US, what is the US interest? And so I think that part of the US interest is sending a message to this country, to these, this group of violators or people who commit violations like this. And so if there is little harm, then it sends less of a message. So I think if everything else is equal, they probably would choose someone who had more of a connection to the US. But I don't think that that will factor in at the first, second, third, fourth level. I think that that comes in really at the very, very end.
Thanks for the answers. Let's move forward. Since the Magnitsky Act was having passed in US Congress, there's been a few other countries which was also entered the way of implementation of this act. The Canada in a certain way, the UK in a certain way, Lithuania, and now we just seen the green light from European Parliament on certain human rights legislation. Mm-hmm. Can you give us some more insight on how it actually works around the world, excluding the US list?
Sure. So the Canadian law is very similar to the US law. And it's just entering the implementation stage now. And so we've spoken to the Canadian government, and in our this year's 2019 submissions, we'll be taking all of our submissions that we submit to the US government and also submitting to the Canadian government. So that's going to make it really easy. Those are similar enough that we can just do one and then the other. Great. The UK law, the UK Global Magnitsky law, is actually one that will not go into effect until Brexit happens, which is, who knows what's going to happen. And so we are not going to hold our breath for that. We're just going to wait and see. However, there is a separate piece of legislation that was passed a couple of years ago that enables someone to get a person sanctioned if they have committed torture or cruel, inhuman, or degrading treatment. And then you actually have to go to a court, to a certain court in the UK. And you present evidence in front of that court, and you can, if you present evidence of torture by that individual, you can get them sanctioned in the UK. So it's kind of narrow, and it's not very global. It has a global Magnitsky angle. And then, as far as I know, it's not just Lithuania, but all the Baltics. All the Baltics have a visa ban that is based on human rights violations. And so they have some sort of similarity. And then, I think the island of Jersey, passed something similar. And now the EU, as of yesterday, had a vote. And this doesn't mean that Global Magnitsky is going to be happening in the EU right now. What actually happened is that the Dutch government had this idea to initiate a process for bringing some kind of, I'm about to say Global Magnitsky, but actually they are not sure they even want to call it Global Magnitsky or Magnitsky related. They're considering the politics of having the name be Magnitsky. So some kind of human rights sanctions. And so the Dutch put together a proposal just to put forward the idea that maybe the EU should consider having some kind of human rights sanctions that target individuals and not states. Because right now the EU can target states and sanction basically a government, but they can't sanction individual violators. And so initially we heard that on November 20th, there was a big meeting. My boss actually, met with a bunch of governments and talked about how NGOs are involved in the process in the US. And we heard that there was support, but the Dutch were not sure that it would actually pass. There were a number of countries that were not sure that they wanted to move forward. I think part of that was the name Magnitsky, and so I think that may have been one reason why the Dutch are not pushing the name. Some had concerns about due process and getting off the list, and others I think had political considerations that they didn't want to, they weren't sure how this was going to be used. And so actually, sort of on the spur of the moment, some NGOs got together and wrote a letter in support of the idea of the EU considering the idea of human rights related sanctions. And so 90 NGOs signed a letter of support last week. And I know Bill Browder was also heavily involved in lobbying the EU to have human rights sanctions, to have what he wants are Magnitsky type sanctions. And he also worked with a bunch of MPs in the European Parliament. I think he got over 50 MPs from like 18 different states to sign a separate letter. And I do think, I don't know about the MP letter, but I kind of think that the NGO letter definitely helped push it over the edge. And some of the considerations and next steps will be for actually framing the language. What is this going to look like in the EU? And one of the ideas that has been put forth is to try to have some kind of independent commission that makes the decisions, that's made up of human rights experts, rather than having the MPs themselves being the decision makers about who actually gets on the list. They're wanting to try to take it away from political considerations, which is, I think, a great idea. I do worry, we've been approached by folks in a number of countries who have said, oh, our government is thinking of passing a Magnitsky law, what should we think about? And in some countries, I worry that, it's going to be, like the aim of the law is to identify a political opponent, or like a George Soros, and then just put them on the list. And so what we're doing now in the US is we're trying to consider ways we can make the US law more political use proof, more sort of less prone to political use. And we're thinking of checks that we could put in place and how we might get to legislate them and maybe modify the Magnitsky law so that if it is replicated elsewhere, then it will be replicated with these checks in place.
All right, that's actually, I mean, the news from European Parliament, I think, are very in time to the, the anniversary of the Declaration of Human Rights.
Yeah, that's right.
That's very good timing. Melissa, you didn't mention the UK law, and that's, I think, an important question, how it's going to work, because the UK is actually the country where a lot of bad guys keep their money.
Yeah.
So what about the law in UK?
So what I said is that the Magnitsky law itself is tied to Brexit. So it will only go into effect when after Brexit happens. So after the UK becomes its own independent entity, then this law will go into effect. Now, because the EU is considering sanctions, human rights-based sanctions, while the UK is part of the EU, we hope that it will help pass these sanctions. But for now, it only has those judicial sanctions that I mentioned. So that is only torture-based. It's not even broad human rights. It's only torture and cruel and inhuman and degrading treatment. So it doesn't affect corruption at all. So for corruption, we're kind of out of luck in the UK right now. There isn't anything that you can put forward. It's going to have to be post-Brexit, or let's hope EU sanctions pass if they stay in the EU.
Oh, okay. Any more questions?
Can legal entities or multinational corporations be included in the list? And if not, is there any idea of expanding the efforts of the list?
So the list concerns individuals. However, then any corporations associated with those individuals can be secondarily sanctioned. Yes. So there's an example of Dan Gertler, who is actually an Israeli who is operating a number of different mining companies in the Congo. Essentially, as a result of him individually being sanctioned, you had like 67 different companies then put on the list. So, but largely the companies that are on the list they're all secondarily sanctioned. They're mostly his, but there are a number of others that are connected to other individuals. So, and let me talk about secondary sanctions really quick. So, secondary sanctions can apply to companies. You can also see, and we just saw this yesterday related to the Gambia, you can also see family members. Once someone gets on the Magnitsky list, the US has a secondary sanction provision, it's not in Magnitsky, it's separate, that they can use to sanction family members who may have been involved in these acts, and so that they can be subject to visa bans and having their assets frozen. So the family members and corporations can be secondarily sanctioned.
That's particularly important for those involved in corruption, right?
Yeah, that's right.
Oh,
yeah, you had mentioned a couple of times the freezing of assets for persons who are named to the list. Where do we stand in terms of recovery and repatriation of stolen assets? In the US or elsewhere with global partners?
Right. So the easy answer is I don't know. I think that that the US has not prioritized the repatriation or going after those assets that it should be identifying and bringing back. It hasn't prioritized that. So I don't think we've gone very far. They are really looking at the easy targets. So those that they can identify clearly in the US that they can freeze with maybe just a phone call or a very easy bit of research. So unfortunately, it's a great question. We haven't gotten very far.
More questions?
Say you were an activist in a country where the head of the state fiscal service was very corrupt, and the country was also a close partner of the United States. How would you go about getting that person on the Magnitsky list?
Yeah, the relationship between the country and the US is a major consideration. So that's a good question, but I would say that is why why the Magnitsky law is seen as a step forward, in that it tries to decouple individual human rights violators from the relationship to the country. So what will happen, the person should document clearly the violations, the corruption that the person has engaged in, and the connections of this individual to the corruption. And then what will happen is that once that comes into the State Department will call up the embassy of that country and say, hey, what would happen if we designated, I don't know, this guy as a violator under Magnitsky? And the embassy, as it always does, freaks out and says, that will be terrible, don't do it. But there's a negotiation that happens. And sometimes the State Department says, you know, we have really clear evidence here. We think that, you know, we need to put this person on the list. And sometimes the embassy says, if you do that, it will completely ruin our relationship. And so I think that that's why we recommend that when possible, activists provide kind of a ladder of those that are involved. And there's very often a high-level official involved, but we ask that, or we suggest that people include the sort of deputy that's also involved, and sort of go down, you know, a couple of levels and provide some options, because that allows the US government to decide at what level they want to disrupt the relationship. Sometimes what they will do is they will designate a deputy and put them on the list when the chief was involved, sort of as a signal to the chief, like, we are watching, we know that something's going on, and so we've got our finger on this, but we know that we can't designate you because you're too high and it will destabilize the relationship, but we are paying attention. We've seen that. But you're right, if the relationship, you know, like, I think Khashoggi's murder is a great example. The relationship is with MBS, and that's who should be on the list. What did they do? They designated high-level officials around him. They didn't designate him. But the fact that they designated, you know, 17 people, high-level officials in Saudi Arabia, that is some kind of signal. So they're trying to weigh the politics and the relationships, and they're also looking at the human rights implications. So that's what we're negotiating with right now. And then I think, okay, the other thing is that if you were that activist, I would say, if you can, contact members of Congress or work with human rights groups in Washington to be in touch with members of Congress, because the Saudi Arabia designations happen because you have, you know, the entire Senate Foreign Relations Committee, except one person, saying this needs to happen, and putting pressure on the government. And if you get a champion in Congress, and then that person can help you get another champion in Congress, you can actually put real pressure on the US government to sanction.
Right. Anyone else?
Maybe just one remark. As I know, one activist, Petr Miloserdov, now he's sitting in the same cell, prison cell, where Mr. Magnitsky spent his last days, and he's sitting there more than 300 days. And Mr. Miloserdov, is accused in some strange things, like he was preparing the cow in Kazakhstan. Yes. Yeah, it's quite fantastic. His case is about 10 pages, and he's sitting in prison more than 300 days in the same cell.
Yeah.
So it's like the fact.
Yeah. So when it comes to identifying human rights violations for Global Magnitsky, it really is generally things like murder, disappearances, torture, cruel treatment, where we've seen arbitrary detention has to be the person has to be detained in some extraordinary way. So detained without charges for a long period of time, or detained with some other cruel treatment, like maybe they need medical treatment for a particular condition that they're not getting. But actually it's a harder use for us. We've had a number of conversations with the US government about this, asking them, what about arbitrary detention? Like, what kinds of arbitrary detention? And we have heard arbitrary detention, yes, can factor in, and someone who has engineered such a detention could be put on the list, but it has to be extraordinary in some way. So I don't know, like 300 days, like almost a year, maybe you would argue, this person has been charged with fabricated charges and they're just not being brought to trial because they don't want to face the fact that they have a really bad case. Like maybe, but think that they're getting like hundreds of cases because we're submitting cases, Congress is submitting cases, they're doing their own cases, and so they're trying to weigh all of them. So it has to stand out in some way and have a US linked interest also, which can be sometimes hard to articulate.
Okay. Melissa, I got the following question. When the Magnitsky Accountability Act was about to pass in Congress, there was a certain public opposition to the decision, including the opposition which was co-sponsored, let's say, by Russian authorities or affiliated institutions or persons. Is there an opposition for the Magnitsky Act in the United States right now? Or is there like a certain groups which are trying to somehow soften or influence on the decisions on the Magnitsky Act?
Not really. Dana Rohrabacher is not in office anymore.
So
that helps.
Yeah, that was a lot of. We celebrated a lot of Rohrabacher.
Yeah,
get out.
There's that.
Yeah.
I would say no, and in fact, what we're seeing legislatively is we're for the next term, we're seeing a few pieces of legislation that are trying to use Global Magnitsky in more specific ways. There's a comprehensive sanctions and immigration draft piece of legislation that's looking at what could be done in LGBT-specific cases. We're seeing sort of ways to make the sanctions sort of clearer, maybe a description of how people can get off the list to sort of strengthen the act and make it, strengthen the law and make it more clear for people who are concerned about the due process aspects of it. But no, we haven't seen, since it's passed, we haven't seen anyone trying to get rid of it. People, I think, have just accepted that it's there, and now people are just trying to kind of tinker with it.
Okay. So my last question is, what's the future? Where do you think should this practice goes? Should it be like a worldly implemented practice like in Europe, in Ukraine, elsewhere? I mean, of course not in Saudi Arabia, but or should it be more conservative and more, tiny institutional tool which could be used only in a very specific certain cases?
Yeah, I think, so I referenced a couple of these things. We have concerns about the idea that everyone should have a human rights sanctions law because the way some countries will use the law is to misuse the law. And so what we're trying to do is think of ways we can make the US law better and tighter and more protected from political use so that when other countries say we want to have a human rights sanctions law, there are standards in place for what that means. And so we're looking at how to involve human rights experts or have some kind of maybe commission or some body that might assist with review, but we haven't, honestly, we're just starting on this piece. We've begun to identify the problem over the last couple of months, and so we're now talking with some of the EU partners who were considering this and trying to figure out, well, what would that look like? Because I don't think that every country should have one. No, you mentioned Saudi Arabia, but I am even thinking of a country like Hungary. I don't want Orban to have this tool right now. So we are looking at that. I think that's the biggest issue, is trying to prevent political use. We are also, on the more pro-human rights side, we are also looking at cases where we see corruption crossing borders and trying to involve NGOs from two countries where money from one might, go into flow into another, and there's a corrupt scheme that involves both countries. We're trying to look at those instances, and then we're also trying to look at instances where you see corruption funding human rights violations, which I kind of feel like happens all over the place, but trying to articulate the connection between the corruption and the human rights violations in some cases to try to highlight what that looks like in various parts of the world. So that's what we're looking forward to, hopefully, in the next series of designations. And then, as I said, making the law better and more workable. And maybe the EU will also contribute some ideas and help the US improve our law as well.
Okay, thank you.
Thanks.
We got time for 1-2 more questions. Is there any? Okay.
Can I actually ask a question?
Yeah. Sorry, I just didn't see you. Yeah, go ahead.
No, sorry. I'm curious if you can talk about the Russia Magnitsky law and what your organization's involvement in that work that you guys done so far.
Sure. What has happened so far, or recently, is that in terms of the State Department's development of cases around Magnitsky himself has kind of dried up. They've sanctioned everyone they think they can through that particular angle. And so now when we develop cases related to Russia, so for example, the coalition worked on a number of cases related to Chechnya in the last round, we put them forth and they will ask us, is this global Magnitsky or Russian Magnitsky? And if it's a human rights violation, we say Russian Magnitsky because that's mandatory. And so if it's corruption, it's global Magnitsky, and then it's elective, and so we are just waiting for them to determine whether they will sanction. So we're looking for more sanctions on Russia based on some of the Chechnya cases, because, yeah, I mean, that's mandatory. But we aren't specifically going out looking for Russia cases under Russia Magnitsky. It's part of the coalition. We have a number of groups that are investigating, corruption in Russia, human rights abuses in Russia, and so they put the cases together. And then, yes, when we put them forth in our advocacy meeting that we have with state, we say this can be designated under Russia Magnitsky, and they say okay, and they check that box. And that is true actually for a number of other countries as well. They're not necessarily human rights sanctions, but there are other types of sanctions that are applied to other countries. And so we get asked that question, which sanctions regime do you prefer? And basically, most of the time, we don't prefer any one, but sometimes there are other sanctions that are mandatory or that carry some other weight, and so we might prefer them to global Magnitsky. But short answer, we're not doing anything special on Russia Magnitsky. But it is part of the coalition.
All right. Thank you, Melissa.
Thanks, everybody.
Thank you for coming to this beautiful city. Waiting for you to come back.
Yay!
Thanks, everyone, for coming to one of our last events this year. Don't forget to like our page, follow our YouTube, everything what's needed. See you soon.